Quick disclaimer, these discussions are intended for education and informative purposes. They are not to be used as legal advice. Welcome to the 256. I'm JD, host of the 256 Investor Podcast. This is for both the seasoned investor building a portfolio of rental properties that wants to sharpen their skills and for the potential investor that needs to answer some questions and gain strategies to invest with confidence. We'll discuss all things investing, legal, tax planning, acquisitions, insurance, and of course, we'll discuss real-life experiences with 256 investors. Whether you live in the 256 or invest from afar, this is for you. Thanks for joining again, 256 Investor Podcast. We're here with Geoffrey Middleton today of Middleton Law Firm. Geoffrey, why don't you go ahead and tell us a little bit about yourself and your company?
Yeah, man, it's a pleasure to be here. Thanks so much for having me. I'm Geoffrey Middleton. I am the attorney and sole practitioner for Middleton Law Firm. We are a company that handles primarily residential and commercial real estate sales, and so we do the closings for those. I also have a law firm in Tennessee called Young & Smith, so we operate in both states. And it's funny because the Tennessee office is more agricultural farmer investment and Huntsville is more commercial and residential investments. And so I get to see a lot of different things. I've been doing this now for 10 years and I just really enjoy the academic side of it, honestly.
Well, I've known you most of the time you've been doing this. And one of the first questions, the first question I always get from a potential investor or someone who's investing in Alabama for the first time is, how do evictions work? Which is always a silly question because they're going into that with a totally negative attitude. It sounds like to me, their very first thing they want to know is, how do I get somebody out of my house when it goes bad? So I usually have the conversation, you need to maybe assess if you really want to do this, if that's your first question. We'll get to that another time. You can touch on evictions if you want to. But one of the follow-up questions I get to that right after that is, what kind of entity do I need to form, or do I need to form an entity if I'm going to be investing in real estate?
Absolutely. I will say on the eviction side, I do not judge people with that first question because on your basis, you need to understand the cost and timeline associated with that process. You don't expect for it. You plan to avoid it, right? That's why we have people like you in our lives. But just knowing it is never a problem. And I highly encourage people educating themselves. On the LLC front, or on the what do I form, is the LLC the right thing to do? There are, as everyone knows, multiple entities we can form to kind of protect ourselves. The name of the game is liability, right? I'm trying to limit how much liability I take on while I increase my investments and holdings without putting myself too far out there. The main thing we want to focus on there is I have a difference in my personal assets from my investment assets, and I want to keep that wall up as much as I can. And so if something happens with my investment property, I don't want them suing every other investment I have and having a domino effect take, and then the end domino being my personal home. And so not only do I want to separate a wall between me and my personal assets from my investment, I also want to separate each investment from each other, especially in real estate, because it's very possible that if I have one entity for every holding I have, and then one holding has a bad situation happen, then we're in a process where now all my investments are at risk of a large lawsuit. And so the first thing I'll tell you, just real simple, is every investor should have an LLC, right? That limited liability company. The very next question you're going to have from any investor is, where do I form it? What state do I go to, right? And so in that regard, I will tell you LLC laws in particular, 15, 20 years ago, the answer was Delaware, no questions asked. This is what we're going to do. This is where we're going to go. They're the state with the most laws, with the most comfort, with the court set up to handle it, right? Nowadays, that is not so much the priority. If you're going to be a Fortune 500 company and you really want to have that LLC background when your attorneys are understanding how the courts are going to handle things, Delaware is still a great place to go. But if we're just a daily investor trying to do some real estate dabbling, there's lots of states that have mimicked LLC laws from Delaware and other states. And at this point, you can pretty much do it wherever's most convenient for you. I encourage you to talk to your CPAs about the balance between the taxes and how the states handle that aspect. But from the legal liability side, we all have great LLC laws at this point. And so Alabama does have a good law. I form LLCs all the time here in this state. I will tell you, for our out-of-state formers who want to create their LLCs in other states and then work here in Alabama or hold properties here in Alabama, you do have, that is what we call a foreign LLC to Alabama. So when I say foreign LLC, I don't mean it's out of the country. I mean it's out of the state. And so if I have a foreign LLC and I want to do business in Alabama, Ideally, I'm going to register as a foreign entity in Alabama with the Secretary of State here so I can be a registered company paying my privilege tax, doing the things I need to do. If I'm making income, I'm paying the income tax, right? Because when I go to sell that property, someone like myself is going to ask you for something like a certificate of compliance or a certification from the Secretary of State that states you don't owe any taxes and you've done everything you needed to do to operate your business in our state. If you can't get that document because you aren't registered and you haven't paid your taxes, I won't let you sell your property, right? Because as a title insurance agent, someone who is coming in and guaranteeing that the property is good for the next buyer, I want to be able to maintain that everything is clean, including potential tax liens. And the state does not play games. They will come after you for this. And so that is something that I think is a caveat to the LLC formation that gets left off the conversation quite often.
And something like a certificate of compliance, which is what we have here in Alabama, that is an annual certificate that one gets. It's not a one-time forever.
Absolutely correct. And that catches a lot of people off guard, especially seasoned investors who may have worked with a title company that maybe didn't require it because they were willing to take the risk there. And so the rule of thumb for every title underwriter in the country is that you get these. Whether the title company requires it or not, it's a whole different story. So I will say that there will be some investors that listen to this and go, I've never been asked for that before. Am I doing something wrong? No, the title company just didn't follow that protocol, and that's perfectly fine. But a lot of them, like myself, will require it, and it's important for you to know what it is and how to get it. Typically in Alabama, you can get it within 12 hours, right? It's an online registration. It's a single form you fill out. It's like $15. And so there's not a time issue. There's not a money issue there. What will delay you is if you have not properly set up your company with the Secretary of State and aren't properly paying your taxes, they will tell me they cannot give you one. And then they will tell me I have to wait until they can process you and verify that your taxes are paid. Alternatively, if you have registered but then never paid your taxes, they may tell me, hey, this company looks good, but they are owing me a certain amount of money. Then I'll come back to you and say, hey, we can't close until you pay your bill. And we may pay it through closing, which is fine with me, but we still have to address it. It's still a timeliness issue, and no investor likes their time messed with, right? Every investor's time is more important than anything else they do because that time is how they make their money. And so the last thing I want to do is put them in a situation where they're not prepared for the moment that delays their closing, and now they're upset at everybody, right? No one's going to get out of that one.
And I ran into that situation personally a few years ago when I was purchasing. The seller was really adamant that they didn't want to get a certificate of compliance, but they claimed there was nothing wrong. They just didn't want to take the time and the hassle to do it. Well, it turns out they owed the state money. So where does that, again, just reiterate where that benefits me as the purchasing investor to know that they cleared that up with the state and were forced to get that certificate of compliance to show that they're in good standing?
That's a great question because investors are on both sides of the deal, right? We buy and we sell, and we sometimes buy from other investors. And so it's important from a purchasing side that your seller give that certificate of compliance because, again, if those taxes are applied to the property where you were holding it and then you've already purchased it, you could be liable for that potential bill on the property. And so, again, part of title insurance, which is, again, a big part of closings, is going to say that when you purchase it with title insurance, we're telling you your property's clean. There's no liens, there's no judgments. Every previous owner has properly conveyed to the next owner in line. And part of that lien and judgment verification process is with taxes. And as everyone knows, the state and the feds, when their tax protocols hit, you can't just ignore them. They're very powerful liens and they attach to the properties directly. And so we have to deal with them. Yeah.
We'll come back to that a little bit later. I do want to go back to different LLCs. I've had investors ask about Series LLCs. I think these have been very popular in other states like Colorado for quite some time. I don't see a lot of them here. Maybe you do, but talk about the advantages and disadvantages of having a Series LLC.
Fantastic question. Alabama is new to the game. I think we formed our Series LLC laws in 2017. And if I'm being just completely frank with your listeners, our laws are not as detailed as other states' laws. So we have left a lot to the imagination as far as how we're going to function with our series. And so while we have the basics there, we can do it, we can operate, we can start talking about it. Some investors have chosen to wait until more lawsuits have been filed, more things have gone through the court so they can have a better expectation of risk management. Because currently, the Series LLC system sounds amazing as an idea, but when it comes to the practical nature of what happens if I get sued, how does this play out? There is some ambiguity here. There's also a little ambiguity with how we name our series. So for those who aren't familiar, a Series LLC basically allows you to form a single master LLC. And then that master LLC can then have a bunch of little series that branch off of it. Each series then becomes its own separate liability shelter. And so they will not attach to each other. So that accomplishes both tasks we talked about at the very beginning of the podcast. I want to separate my personal assets, but I also want each of my investments to be separate as well. The key to a Series LLC is that you have to maintain the accounting very clearly, and you have to have a separate operating agreement for every series that you create, because just like a normal LLC, every series can have a different ownership structure. So for our investors who may have different partners for different deals, a Series LLC, while it may have a master operating agreement that functions at the highest level, each series you create can then have its own structure that's separate from the master. Now, again, I highly encourage any investors wanting to play with a Series LLC, talk to your accountants first, because you want them to be comfortable with how they're going to file with the feds and with the states. And typically, even though every series has their own record keeping, their own accounting, you file your taxes as a single conglomerate. And so you have to have really good records, not only to maintain your limited liability of each one, but also to then combine them all for a single filing.
I'm not hearing a lot of great reasons to go down this road just yet, because all you've told me are disadvantages. It sounds like a lot of paper shuffling. And plus, if unless you're a cash buyer, if you're getting loans, I've never purchased a property with a loan attached that I didn't sign something saying I'm personally guaranteeing this as well. So there's still going to be some liability. Is there any way to achieve full protection and have things really completely separated? Because I'm yet to find it.
No. We, in law and in investment, as everyone knows, we want to set ourselves up for defense, but we can't guarantee impenetrable defenses, right? We just set up as much as we can. And with that regard, from every investor, you want to have an LLC, but you also want to have insurance. You don't want to have insurance and not the LLC. You don't have LLC and not the insurance, right? These things work together, because when anyone gets sued, a wide net is cast. No single party gets sued, right? It's always individually, your LLC, anyone who happened to be in the area, anyone's mother who happened to be close by. Like, we're going after anyone and everyone. We'll go after imaginary parties, right? Lawyers do not stop the legal lawsuits just because we may not know exactly who to go to. We'll make up people.
That's why insurance agents will sell you umbrella insurance all day long.
100%. And again, you can have that LLC protection, then you can have the individual insurance for each property, and then you can have the umbrella policy on top of all of it. A prudent investor will consider all three of these options.
Yeah, it's not something I advise people to do yet, to be honest with you. The Series LLC, I think it does have some work to do, and I think you just spelled that out. And I think for people in other states, they are set on that, but I don't think we're quite there in Alabama.
I would tend to agree with you. When it comes to the series, the idea was, if you are a seasoned investor and a serial investor and you're doing a lot of things, every LLC you have to manage has to have its own separate filing, right? And as we just talked about, if you have a series, it's a single filing. And so there's not as much privilege tax to be paid there. There's not as much accounting to be done there, ideally, is the idea. I don't know how effective that actually becomes, because then you've got to work with your CPA and accountant on, once again, the nuances of how that series functions. But that was the general idea when they created it.
Right. It's a lot of paper shuffling. It's a lot of privilege tax payments. It's a lot. I don't know if the return is there.
I tend to agree with you. The old system is just create a new LLC for every investment you have, and there's nothing wrong with that. It's tried and true, and it's proven to work.
Well, other forms, what outside of LLCs, do you do S corporations and other things like that?
Yeah, absolutely. So when it comes to specifically the investor and what works best for them, LLC is going to be the default, because just to really describe how the LLC functions, the LLC is kind of a made up concept. The feds don't even recognize an LLC. If you go to file your taxes, you can't say I'm an LLC, right? They're going to see you as a sole proprietor, a partnership, or if you elect to be seen as such, they will elect to see you as an S corp, right? But when it comes to other options that we have, we can do LLCs, trusts, corporations, S corps, and all of these things kind of change based on how many investors do we have? How are we functioning together? What is the ultimate goal of the investment strategy? The S Corp is okay because it's a more formal kind of median ground between the LLC and the C Corp. The C Corp is a very rigid structure. Got to have a board, got to have people that you report to, got to have annual meetings, got to have annual filings, right? Very formalized. So I don't typically recommend that for my investors. Like I said, the S Corp, taking a step back from that, a little nicer, still requires some formality, but not too much. The LLC is the marriage of I just want to get it done, but I need to have a formal structure around me. And it makes you kind of the king of your own domain. You can kind of set your own rules. There's no formal requirements for filings. There's no formal board structures that you have to have. You can set it up however you want. So then it comes down to your conversations with your attorneys. How do you want to set up your operating agreement? How do you want to function with your partners? How do we want to function with who owns how much of this based on how much they put into the company and how much we're handling with our investments? And so that to me is where we should focus most of our energies, is really on the LLC conversation of how can we make this function the best way possible? And like I said, if you're trying to get the best of the tax world, which is I think the S Corp tax structure, with the freedom of the LLC, then you just form the LLC and do the S election on the CPA tax filing.
Right. And if you go multi-member LLC, you're going to have to file a 1065 partnership return. If you do an individual LLC, like you said, it's just going to go through on your personal 1040. I think a lot of people will have paralysis by analysis when they start getting into all this. The easy answer is just do the LLC.
That's it. That's it.
Said, and elect the S corporation. A lot of people just can't get over this hurdle of how do I form this? It can always be changed. It can. But a lot of people just can't get over this hurdle. I think we need to talk about it, but also we need to get past it to move on.
So brass tacks, right? That's what we're really talking about here. When you're forming and starting up as an investor, the LLC takes 30 minutes to form, right? Most states nowadays have their own filings that are very easy to do. The only reason you really pull in an attorney now is to get the operating agreement worked out, not to get the initial filing done, because you can file anything on your own very relatively easily. And so when it comes to the brass tacks of the LLC and why are we doing it in the first place, we've already talked about we're going to form the LLC because it's going to separate that curtain between me and everything else. The thing that does that separation is the accounting. If you are planning to set up your LLC and then just wing it and handle it like your personal accounts, you are not doing yourself any benefits. You have to have separate accounts. You have to have that EIN or some sort of taxable identification number that is assigned to it. You need to be able to show that this operated individually from you. And if I look at your LLC and I see you buying groceries with your accounts, you are your LLC. And when I sue your LLC, I'm really suing you and I'm going to pierce right through it. And there's nothing that's going to stop me from doing that because you didn't use it properly.
You know, piercing the corporate veil.
That's it.
Yeah, you've got to maintain separate bank accounts. And this is something that way too many people just, they gloss over. They form the structure and then there's no structure after that.
That's right. Yeah, and that's why I tell people the LLC is great, but I don't trust my investors to handle their LLC properly, which is why I always, when they leave my office, tell them, go to your insurance agent next. Because if you fail to handle this properly, at least maybe your insurance will buffer the hit, right? And help a little bit.
And before we move on, I want to touch on this. How important is it to, if you have a multi-member LLC, to go ahead and set up a divorce decree? Because it's probably going to come to that at some point.
Yeah, a lot of these operating agreements are very customizable for estate planning. And so I would highly recommend that these multi-members have that conversation with their attorneys. You can do, life insurance policies that marry into the operating agreement itself. You have buyout agreements that can happen there. A lot of people don't think about it. When I go into partnership with you, if something happens to you, who gets your interest in the LLC? Does it come back to me as the remaining owner, or does it go to your family? And your family can now be in the LLC with me as an owner with me, right? And how's that going to function if they try and upend our investment strategies because they didn't agree with their loved ones? And so having that conversation is why you go to an attorney and don't just go online and form it yourself, especially multi-members. Single members, you guys are in a whole different realm of control and flexibility.
Especially with unrelated members. I'm sure that I don't have the statistics in front of me, but I'm sure there are more breakups than people who stay together through these structures. I think it is very important to have a structure for how we're going to get out of this thing when it comes to that. Nobody wants to admit that going in, but that's usually what it comes to.
No, but again, every attorney is going to sit you down and have that moment with you of like, I'm glad everyone's so excited, so pumped, so trusting of one another, but we're going to pretend right now that it's already failing. how is it going to fail? How are we going to have that golden net, that golden parachute function for everyone involved so that there isn't that big fight at the end? Like you said, these LLCs and these investment groups that we form, they're partnerships a lot like a marriage. They require great communication. They require a lot of investment in time and a lot of energy. And we know the divorce rates, right? They're high. So why do we think LLCs are any different? You need to plan for that out.
Especially with more money involved. A lot of marriages don't work out because of finances, and when you have more finances, more money involved, it's not great. We've probably all been through them in partnerships, so it is important to go ahead and know ahead of time how you're going to get out of this thing. I recommend everybody have a strategy.
Absolutely. Completely agree.
So we've got our structure set up and we're ready to start buying properties. We go through the contract process to get one under contract, and outside of appraisals and inspections and things like that, where do you come in to this to get this to the closing table?
Yeah, fantastic question. So my involvement is after you get a contract down, you're going to send it to my office. And my office is going to immediately do a title search. What we're looking for are clouds on the title or breaks in the title chain. A lot of times investors end up buying the more undesirable properties that maybe a family wouldn't go near, but investors going to be like, I can fix it, right? I can make money on this. And so when that happens, we tend to have a more complex title chain. Some tends to be that these houses have been in a family for a long time. They haven't been well maintained. We may have had multiple family members die off since the initial holding. And so we may be dealing with an estate. We may be dealing with heirship issues. We may be dealing with lost heirs. I've had closings in the past where we had a large family come to the table and they identified each other very willingly. It's kind of just to find out one of their siblings had died and left two kids, and they ignored them, left them off the table completely. And we only found them because we do a title search and we do obit searches, and we try and find death certificates, and we try and find evidence to verify what the family's telling us. And so in that situation, we had to go track them down in Texas and let them know, hey, your family's selling property that you technically own a part of, and you need to be involved in this, right? And there's all sorts of tools that lawyers have to incentivize this process. When it comes to if we hit a cloud or a chain issue, I may say, it's been more than 2 years. We don't have to open an estate, right? We don't have to go through that formal process, but we do have to get the family to find somebody to tell us who the proper heirs are through an affidavit of an unrelated party that doesn't have any financial skin in the game, so that we can move forward confidently without having to go through those formal processes. So I always encourage people, don't get, too concerned when someone comes to you and says there's a cloud on title or there's an heirship issue or something's going on. It's not the end of the day. It doesn't mean months-long delay. Talk about the options with the attorney. Figure out, is there an affidavit we can file to fast track this? Is there something else we can do?
We had mentioned earlier about the certificate of compliance. At what point does something come in where it's not somebody's fault or intention, but things come up like an unreleased lien, like unrecorded, just wasn't recorded with probate? Those things do come up. And how do you address things like that were really nobody's fault except for the person who didn't record? Or, well, we don't know if someone just didn't deliver it to the courthouse or if someone didn't properly record it. But again, this is things I've dealt with at least 3 times over the last 5 years of an unreleased lien for a payoff. How do you address those things?
It's a great question. And it's different depending on what side of the coin you're on, right? Buyer or seller. And so if we have our investor coming in and I tell them, hey, there's this cloud on title, there's a lien that's unreleased. If they're the seller, then they can come to me and say, well, I got title insurance when I bought the house and they told me this would be cleaned up and we shouldn't have to deal with this right now. I say, great. Send me your title policy. If it's within 10 years, I can even give a reissue credit to the closing and I can save everyone money on the table. A lot of investors don't realize you can use those owners' policies to reduce the owner title insurance fees for the next closing if it's within a certain time period. In addition to that, it does give you that coverage where I can say, hey, there is that lien that was 10 years ago. You bought the property 5 years ago. It should have been released when you bought it 5 years ago. Give me your title policy. I'm going to what we call write up from it. So I'm going to say, I don't have to fix that issue because someone else already covered it for you. So all I'm going to do is focus on everything else since you took title. And I'm going to cover everything from that point on. So that's a very easy way to, and a good reason to get title insurance and fix problems that may, like you said, should have been fixed but weren't released properly. Other alternatives are if you don't have that or can't find it, or you just didn't get it because you didn't think you needed it, you have to go then find the people who are holding that lien, the attorneys who are processing those payoffs, and tell them, hey, you guys didn't do this right. I need you to file the releases appropriately. And that can be a delay to time. If we can't find them, we may follow up with the closing office who did the previous closing and say, hey, did you pay this off? And they say, yeah, we actually have proof of that payoff. We have a check we wrote to it where it was deposited. We're going to send you that proof of payoff. So now you can comfortably tell your underwriters, it wasn't released, but it was paid off. Here's the proof of such things. And then we can move forward from that. So like I said, even the weirdest, most complex problems sometimes have simple solutions as long as you just talk to them and get all the options on the table. A lot of times we move very quickly in this industry and we give you the quick answer, but not the full answer. So always press.
And I should say, a lot of times these things go through with no hurdles. There's really no major clouds on the title. There's no judgments. There's no liens. But these things do come up. When you do enough investments, you start growing a portfolio, you're going to go through all these things. But that's what your job is. Nobody should lose sleep over this if you're the purchaser necessarily. You're going to be limited to what you can do, and you will have some options of, do I accept some risk with this?
That's right. And honestly, that's usually built into the contract for purchase. So clouds on title, title curative work is what we call this. That is built into the seller has a certain amount of time to be able to cure. And if they can't cure, the buyer has an out. They can cancel the contract, get their earnest money back for inability to get title insurance. This is all one of those contracting moments that's important. So I'll say this. If you're going to Google a contract, at least have an attorney look at it before you use it so that you can verify these protections do exist. Because not only do you want the protections for, can I qualify for the mortgage, but we also want those title protections in there as well.
Yeah, and we haven't even talked about the contract, the sales contract. Right. It's everything in the transaction. It's everything. And we're not going to go through that a whole lot, but it really matters what you have on those few pieces of paper.
It does. And for new investors, I will tell you this. A lot of people think, oh, I'm under contract. I bought the house. I hear that a lot. I've just purchased a house. Well, no, you're still in negotiations, if I'm being completely honest with you. We have a contract signed, sure. But usually that contract has stages to it. There's a due diligence period for our commercial investors. There may be an LOI period where we're not even under contract yet, but we just are talking about it formally, right? And so a lot of times there are stages that you'll say, I've signed this, but now we're going to have to renegotiate in 10 days. Once I do, oh, there's a leak in the roof. We need to address this. And that wasn't thought of when we initially did the contract. So now we're going to renegotiate. And if they won't fix it, and I don't want to fix it, then what are our options? And the contract should lay that out for us pretty clearly about who's going to be able to claim earnest, who's going to be able to walk away cleanly, who's going to be able to cancel it, right? These are all important things to have in writing ahead of time, because I have seen people under contract without these terms in them, and then they end up fighting over earnest and there's no clear person who should have it. Now we've got $7,000 on the table, not really enough to sue each other over, but not really something we want to give up. And we end up in this weird stalemate where the money just sits with the attorney's escrow accounts and no one benefits, right? And eventually the attorneys will turn it into the courts and they'll say, hey, I'm not going to hold this forever. Now you have to go get an attorney to go to the court, to file a suit, to get it back. And I guarantee you there'll be no money left when you do.
And you're just describing every situation I've heard from Joe investor who developed his own sales contract to sell his house. And it almost always ends up in court, and there's money tied up, and there's earnest money that's nobody's. Have somebody generate your contracts that knows what they're doing.
Please. And if you are an investor working with another investor or a wholesaler, every investor is not created equal, right? We're talking to a certain class of investors right now. There is a whole nother class of investors out there that are being a little bit more predatory about the way they do business. And they may present their own contract and it may look really nice, but it protects them, not you. And I've seen investors come in with other investors like I'm talking about, and they'll say, here's the contract. Everyone agrees to it. It's wonderful, nice and peasy. And then immediately out the gate, there's issues. And all of a sudden you're asking for a mutual release and a release of earnest money. Not only will they not do those things, but they are going to file an affidavit in the probate court that's going to say, I have a right through a contract to this property. So if you're a seller working with that kind of buyer, all of a sudden, I can't sell my property without a release of this affidavit of contract. And now they won't release it unless I give them $10,000 to $20,000 because they have a contractual right that they think is valuable. And so now we're stuck in a situation where I don't think they deserve to have this. I think they've broken the contract, but they're sticking to their guns because they understand that lawsuits are expensive and they're gambling on the fact that I'm not going to sue. I'm going to go ahead and try and resolve this outside of court. And now I've got a hit. I'm going to take a hit, right? For no reason other than I didn't look at my contract.
Moral of the story, if you get a postcard in the mail, don't just sign the contract as is. Have an attorney review it thoroughly.
Please.
Not that anybody around here gets postcards in the mail wanting to buy their house.
Never, no.
And if there are loans involved, there are going to be certain requirements from the lender, and you're going to have to satisfy some underwriting guidelines that could be separate from what you would normally handle between a buyer and seller.
That's a really good point, actually. You know, when it comes to the closing process, a lot of people look to the attorneys for the rules of the closing. And honestly, the lender has more control than anybody else in your closing. And so if you're an investor and you're starting with looking at properties and then I'll get my loan figured out after I identify the property, you're kind of doing it backwards.
Yeah, the lender steers the ship here.
Absolutely. Start with your lenders. Get your deals itemized. Figure out what your lines are, what you're approved for, what the process is going to be. Start sending in those W-2s or those statements to prove your finances early because they're going to ask for them 3 more times. And you're going to get to the 3rd time being like, is this the same lender? Like, is this a different department? Like, I've already sent these in. And they're like, we want them again. And you've got to do it or they will delay your closing.
And we don't want to get into the physical inspection of a home, but they're also going to require, if it's on a crawl space, if in the inspection process wood decaying fungus is found, that's going to be something the lender is going to demand get satisfied more often than not. Or termites. They're going to require a termite letter. They should be requiring a termite letter in Alabama. I've seen some that don't, but 90% of the time they're going to. So there are going to be requirements that had nothing to do with the original intent between the buyer and seller, but they have to satisfy the lender's underwriting.
That's right. A lot of investors feel like they have the ability to push their lenders around, and they realize once they're in the loan process that they were wrong. They don't have as much power as they thought they did. I will, 1 second, if you don't mind, go back to I get this question a lot from investors of should I use a trust? And that is something that's getting more and more common to discuss with people. A trust is a complex conversation when it comes to investors specifically, because a lot of people think of trust as I'm going to get all the protections and all the internal freedoms and keep my control while also keeping creditors at bay. That's not really true. When it comes to a trust, there's different types of trust you can form, and the less control you give yourself, the more protection you have. So if you try and maintain control of all your assets in a trust while trying to keep creditors at bay, you're going to struggle to find that balance correctly. And so if you want to maintain that control, you really need to use that LLC. Now, sometimes we'll recommend let's set up that trust that gives you control, but then let's make it the sole member of the LLC. So now we have the trust for estate planning purposes inside nested with the LLC. The trustees know how to operate with that LLC. There's options there. But what I'm talking about specifically with trust is you have revocable and irrevocable trusts. And they're very different on what, again, control gives you and what allows you to put creditors at bay.
Yeah. And now you're getting into the paralysis by analysis that I mentioned earlier. But I see this so many times. And I tell new investors, you're going to have to figure this out on your own. You're asking me questions that are not for me. You need to talk to an accountant. You need to talk to an attorney about these things.
Yes. And estate attorneys are something that you should include in your investment plan, right? Talk to your estate attorneys because a lot of people, they need a basic estate plan while they're creating their initial investments and getting it off the ground. And then they need to have a note in their head that says in 5 to 10 years, if all these investments take off like I think they will, I'll need a different type of estate plan altogether because I'll be hitting different tax brackets. I'll have different liability issues. I'll have different concerns for how I hold my property, and you're just in a different echelon. But don't let that prevent you from just getting started. Right? Like you said earlier, the basic is get the LLC formed, get it rolling, get your investments going. And then later we can always adjust.
It's always good to know there is another platform, something else exists that we can tap into if we need to at a certain point in time.
Absolutely. Yeah.
Once we get through the closing process, obviously, if this is an investment purchase, you're going to want a renter in that property. So where do they go from there if they haven't already done their homework.
Yeah, no, it's a good question. And there's kind of two ways to think about it because if you're buying an investment property, there may already be a renter in there. And we have to understand that we're taking it subject to the current lease that exists. And a lot of people want to come in there and immediately present a new lease to the tenants. Technically, the tenants don't have to agree to that new lease, right? And so if they just signed a lease, you can't terminate the lease unless they fail to make their payments or break that lease in some way. You have to then otherwise wait till that lease expires, typically a year later. And so that is an important due diligence moment for any investor. If you're buying property with someone in it, ask for a copy of the lease, get those rent rolls, see who's behind, who's caught up, right? What kind of chaos are we're going to be taking on with that. But for those people who are buying property that they want to make into a rental that wasn't previously a rental, then that becomes a game of you really are going to want to talk to either a property manager to help you handle that complex leasing structure because goodness, there is a lot that can go into a lease. Or you're going to want to talk to an attorney directly so that you can draft a custom something for you. When it comes to those leases, just to give some high level thoughts on those, you can go as detailed as having house rules that can be used for default purposes in an eviction proceeding. But I always caveat that with it's very difficult to prove these things. And the court's all about proving these things, not just saying they happened. So most people don't evict unless it's a failure to pay rent, even if they break the rules, right? And I think that you're going to do a deep dive in the future on leases and evictions specifically. So I'm going to steer away from that for right now. But there is a lot that can go into your leases as far as structuring the length of time, the amount of payment. And one of the things I don't think people think about is as a new investor, you need to plan for updates to that home and you need to plan for how your lease rent's going to increase with those updates because a house that's not being handled properly over the years is dying, right? And if we plan to keep the rent steady, sure, let's let it die and let's keep the rent steady. But that shouldn't be the goal of our investors, right? We should be looking at increasing the value of our property, increasing the value of our rent, getting the tenants in there that will stay long-term for maximum value. And all these things take some planning. Property managers do this in their sleep.
The lease agreement is as important as the sales contract, I think. There are so many minor things that most landlords, first-time investors never think will come up. But a seasoned renter, they know how to play the game. They know certain questions to ask. They know what they can and cannot do. The lease agreement is very, very important.
That is so true. I have seen so many seasoned renters that know the game better than some of the attorneys doing the evictions. And they know when to file an answer and when not to answer to get maximum time in the property. And this is one of the things that we've mentioned to each other many times is understanding timelines is very important for investments because let's pretend real quick, you have a tenant not paying rent and we're going to evict, but they're good enough to know that they don't have to respond initially. They can maximize that time. And then by filing a simple response, they extend it an extra 30 days in Alabama for just filing an answer. And then once they get that, you may get the eviction, but then they're not out immediately. There's a whole nother process after the eviction's awarded that could go another month, depending on how backed up the sheriff is. So you could potentially be having to pay a mortgage on a property for 2 to 3, 4 months without any income coming in. And you have to be able to handle that. You have to be able to plan for that and know what the risk there is. And like you said, a good lease and good communication with your tenants and good vetting can help prevent and mitigate these things.
And every lease, more or less, is going to be bound by Alabama landlord-tenant law as drafted from Alabama landlord-tenant law, which for those who don't know, it was enacted in 2006, correct?
I think that's right. Yes, sir.
And has had various changes over time, but I don't see many leases that are not bound by Alabama landlord-tenant law, but that in and of itself is not enough. Those are some guidelines, but there needs to be many, many, many other guidelines that are specifically stated between the lessor and the lessee.
Yeah, I mean,
like when you deliver your notice to vacate, the timing that has to be delivered. If these things aren't in writing, it kind of defaults, and you don't want to go to a default as the lessor. There are certain things you cannot do as a lessor, of course, but there are many things you can do to benefit yourself and to set yourself up so that things don't just go haywire once you acquire a portfolio of homes. When you have one renter and one property, it's not the end of the world to stop and work through a hurdle. But when you have 15 or 30 or 45, it's really time consuming if you don't have proper leases in place.
Yeah, a great example of that is pets. A lot of leases go silent on pets, and then they bring in lots of pets, and your property gets damaged.
Yeah.
And that should have been addressed in the lease.
Yep.
because you could have had protection to say, you can't have that pet. You're breaking your lease. I can evict you unless you handle it appropriately.
Right. Yeah, I mean, I could go on and on about the importance of having a good lease agreement, but you do want one from a professional who has been in the game. You don't want to just go Google Alabama lease and go with that.
And I will note here, we're talking specifically about residential property investment. If you have commercial tenants, a whole different ballgame. We're in the wild, wild west. It's contracts at its most basic form. And you can negotiate much heavier, much more aggressively, put way more responsibility on the commercial tenant than you could ever in a residential. And understanding that slight nuance between, am I renting to a commercial renter or to a residential renter, changes the investment strategy dramatically.
Really good point. And renters do have rights. Even though Alabama is a heavy landlord friendly state, renters still have rights.
That's right.
And they should.
Agreed, wholeheartedly. And like we said, a lot of them know those rights.
Right. They do. They do. I can assure you they all do. As they should have rights, but we are speaking of the residential game here because commercial is it's a whole different scenario.
It is. And another weird thing about Alabama, every new investor usually asks about security deposits, right? How much can I charge? How much can I hold? Can I make it 3 months, right? Can I really be aggressive with it? We have very clear laws on that. It's 1 month. Can't go more. Usually don't go less, right?
Right. Don't ever go less, but it cannot be more than 1 month's rent.
Yeah, and how you hold it is very important. How you use it's very important. And there is a strict timeline in Alabama statutes about how you give that security deposit back and how you have to discuss that with the tenant in writing. So you need to give those formal notices, because if you're going to claim that security deposit, we can't just do it, right? We have to give that notice of what we used it for and what it was itemized for, so the tenant can't come back. Because the tenant can claim like 2 and 3 times damages if we don't use it properly.
Right. And in Alabama, you cannot make your lease more strict than the landlord tenant law, correct? So if you have 60 days to provide a security deposit settlement for the previous renter, you cannot extend that to 90 days in your lease agreement.
I think you can always be more flexible with your tenant, but you can't be more strict than the law allows, is my rule of thumb. Right. So like a lot of our leases and just contracts in general will state things like, landlord reserves the right to do these things, but has the right also to waive them whenever he wants without waiving the obligation on the tenant. So if I want to say, I have late fees lined up for you, here's how the late fees function. You know what, this month, I understand it wasn't your fault. We had a weird economy going on, right? I'm going to give you a break this time. It doesn't mean next time you get an automatic break, right? And that kind of thing I think is important to that process as well.
I'll also add that sometimes it doesn't matter what you have in a lease. If you go in front of a judge, the judge is going to rule how best they see fit. And you could have that the late penalty was $50 a day, and the judge is probably going to axe that.
It's very possible. Our judges are very opinionated on district courts. They know exactly what they want to do. They know the law. They go through these every single week. And so they control the court more than anyone else in that moment.
So if a professional tells you as the investor, you do not need to put this in your lease because there's no way this is going to be upheld in a court of law, you should listen to that person because they've been there and done that.
Absolutely.
Something you mentioned was purchasing a property with a tenant in place with a written lease. What if you purchase a property, say, at the courthouse steps at auction, and you acquire a property and then come to find out that someone has been living there, but there's no lease to be provided? Someone is just living there. I know in a lot of other states have made big news for squatters. And what is Alabama's policy if you purchase a property and someone is living there?
This is a fantastic nuance to discuss. So there are 3 different categories we're going to kind of itemize here for this conversation. You have someone with a lease, and to get them out, if they break it, you do an eviction. If you have someone who's living there and they're claiming I'm an heir, or they're claiming I have a right to be here as a potential owner, right? And I'm not squatting, I was given permission to be here.
Courthouse steps purchase, that's generally what you get.
Right.
Is a family member was there, they've been living there, there's no written lease, but they've clearly, that's their domicile.
That's it. And that's an ejectment proceeding. That's a whole different kind of legal action to take. So you have your evictions, you have your ejectments, and then you have your squatters. Now, we recently passed a law about squatters' rights and about how that functions. That's, I think, less than 2 years old right now. And that is still working its way through the court, still finding how we're going to use it, how it's going to fluctuate. But I will say we're glad to have it, right? It's giving us some ammunition to have that conversation. But for the time being, most of the time, you're going to get pushed right back into an ejectment proceeding where you have to prove they don't have title. They don't have a right to be here. Their right as a guest has expired, right? And you have to prove all this to a court and go through a formal process. It's typically longer than an eviction, typically more expensive than an eviction, and typically less attorneys do this kind of work. So now your market to find someone to handle this is even smaller than the eviction attorney list that already exists, right? And so again, something to keep in mind if you're going to be an investor who buys auction properties, you need to do title searches if you can. Like if they're being publicized, go ahead and pay someone $200 to do an advanced title search. Know what kind of liens you're getting into, know what kind of judgments you're getting into, what kind of baggage the property is going to have. Because just because you buy it at auction doesn't mean it's clean.
Right. And I've generally heard that it's a 6 to 12 month process at minimum for an ejectment. I've personally never been through one because I refuse to buy a property with someone living there that does not have a written lease. But so many people, they would never think of this. They're buying something at the courthouse steps. They've never seen it. They're going to assume that they're walking into this property and they can get going. And then they find out, oh, this 3 bed, 2 bed bathroom house is consumed by a family.
That's right. That's right. And that's a very important thing to think about. I mean, same thing with tax sales, foreclosures, auctions. All of these things have baggage. They're great deals for a reason, right? Right. And you need to do your due diligence. You don't lightly invest in foreclosures and tax sales, right? This is something you do your due diligence on first. You have a team of an attorney and an agent knowing how you're going to handle it, because I'm not going to walk the courthouse steps with cash to purchase or certified funds to purchase and not have done my homework.
That's something an investor should do after they've created a nice little portfolio of residential rental homes. Then it's time to look into other avenues. I would not suggest jumping in with both feet with a tax lien or a foreclosure at the courthouse steps. It's not a great way to jump into the game.
Agreed. Your risk factor goes through the roof. You may hit it out of the park the first time and get lucky, but more often than not, you're not going to do that. And you need to be able to balance that risk better as a new investor.
And once one has acquired a portfolio of rental homes, where do they take the next step? You can do some different types of purchasing like we just discussed, but what are some bigger ways to grow a portfolio? If you have 10 homes and they say, I want to ramp this up to 20 homes, without going one by one, what could one consider?
Absolutely. Great question. So I see two different avenues here, right? If we're a flipper and we're trying to hold properties for less than a year and just get it out the door, that is one strategy to take on. And you're really limited to paying those capital gains every single time you do that. And I really can't do anything to protect you there. But if you're a more long-term flipper, you're willing to hold it for a full year, maybe 2 years. You're willing to get the first renter in, right? And then you're wanting to sell it after that initial period. Now we're talking about the possibility of a 1031 tax exchange. 1031 tax exchanges are powerful tools for our investors that want to maintain a portfolio for their entire lives. Because again, the way the 1031 works is that if I have a property and I want to sell it but not pay capital gains, right? And I want to be able to use those capital gains to invest in the next property, which is going to give me a leg up in my negotiations for the next property, give me more to put down. I can buy more property, put more value into it. All of these benefits are coming from that 1031 process. And if we are going to go down that road, the game is kick the can forever, never stop kicking the can down the road, because you're not avoiding taxes, you're moving the taxes to the next property. So if I sell my first property and replace it with a new one under the 1031 game, my gain basis starts from the first property purchase point, and it increases every time I do that. But the game is beneficial in the estate planning process. If you're doing 1031s, you've got an eye to the future. You've got an eye to your heirs. It's the only reason people do it. And you're going to be able to increase a large multi-generational investment tool for your family by doing this 1031 game very quickly, right? All things considered in the investment world. And I think that is something that is great, but you need to understand the rules of how it functions, right? There's certain timelines that exist there. There's certain rules to how you do the exchange. it is not something to shy away from. And there's lots of specialists out there that will give you very detailed rundowns of how these things work.
And it's not something I suggest jumping into right away. Like I can't advise an investor to purchase one property and then a year later try to jump into a 1031. But a few years down the road, this is something that there are a few things that are as beneficial as a 1031 tax deferred exchange. There are some things you need to know about time periods to be able to do this, because you can't just sell and then reinvest the money whenever you choose. There are very specific rules and guidelines about it. So someone who's just getting into the investing game, they're going to have their hands full with so many other questions and answers that this might come a few years down the road, a few more properties down the road. But at some point, to really grow a portfolio, there are a few things that are as good as this.
Yeah, and not to mention the flexibility of it. If I have a property that's valuable but underperforming, right? I may be able to get more by selling it than by holding it, right? But then I may not want to invest in another big property. I may lose my taste for high value properties. I may want to go back to multiple properties that are lower value. The 1031 allows for that. I can sell one and buy four with the value of that one, right? And so if you get to a point where you're like, I need to rework my portfolio is doing okay, but I want to take it to the next level, right? Because that is the benefit of the investor. They get the rents, they get the money that it produces during their lifetime, and then their heirs get it traditionally tax-free, because the federal tax limit right now is up to $15 million. So if your portfolio is under that number, your heirs can take it all with a stepped up tax basis, and you get the benefit of the rent while you're alive. It's a win-win.
Right. They get the equity. You got the cash flow.
That's right.
Yeah. It's hard to beat.
It really is.
And we'll go into much more detail about this another time.
Yes.
But it is something important to note. I think every investor should be aware that there are tax advantages. There are structures available to everybody in this country to utilize.
That's exactly right. And I'll make a comment that I don't think is quite geared to what you're asking me, but I'm gonna do it anyways. A lot of our initial investors start softer than just pure investment, right? They may do a duplex or a fourplex where they actually live in part of the complex. You can separate out how you use that property for this purpose right here, because you have your principal residence tax exclusion that can apply to the residence you live in. And then you can 1031 the remaining value that you were renting out to be able to flip into the next property. And so if you have a beginning investor who's starting with that fourplex, going to have it for 5 years while they're in school or doing whatever they're doing, and then they get out and realize this has been a great tool for now, but it's time to up the game, right? Both of those tax tools can help them do that in a way that they may not be thinking about when they initially got into it. And so again, just having that knowledge, talking to your attorneys, talking to your agents about the different tax tools that are available to us are important.
Right. And speaking with a tax professional is something to do ahead of time. Again, there are a lot of rules associated with this. We won't go through them all right now, but there are guidelines, there are time frames that are very strict. There's no wiggle room with the IRS. So you definitely want to consult a tax professional.
Yes, absolutely. And just acknowledge that anything in the investment world, laws change, rules change, things evolve over time. And that's something if you're going to be doing this as a career for the long haul, that becomes part of your thought process of checking in on the industry. What's going on? Where are we headed? Are there major changes that may affect how I want to invest my portfolio or how I want to transition my portfolio? For our beginning investors or our basic investors that are just holding the few properties they have, don't worry about it. You're doing great. But for our large investors, our ones that are really looking at the generational value of investing, this becomes part of that game.
Well, Geoffrey, we've covered so much today. I really appreciate you taking the time to do this. I think everybody's going to benefit from listening to this podcast. And remind our audience again where they can find you.
Yeah. Again, thank you so much to 256 Realty and to UJD for having me here. I am Middleton Law Firm. Our website is gkmiddletonlaw.com. We do monthly classes that are geared towards realtors and investors. They're free. They're online. You just have to register and log into the class when it happens. We send out recordings to everybody after it happens so that you guys can have it. This is not what we call continuing education courses. We do those separately, but education is a big part of my firm and what we do. So any tools that we discuss in public like this will probably go back on the website as well. So if anyone ever has questions, go to the website, see what information's out there, call our office if you have anything else that you want to discuss with us. We really do enjoy educating the public on what options are available for real estate.
You sure do, and that's what we appreciate about you. Again, that's Geoffrey Middleton, Middleton Law Firm, and this is the 256 Investor. I'm JD. My time's up. I thank you for yours.
That's a wrap on this episode of the 256 Investor Podcast. Big thanks to Geoffrey Middleton for sharing such valuable and actionable insights. If you're already an investor here in Alabama, or just thinking about it, be sure to check out his free monthly legal workshops at gkmiddletonlaw.com. As always, thanks for spending your time with us. Until next time, stay smart, invest local, and keep building.